I have a great pleasure in welcoming you for today's session. Today's session is actually on the insight of the voting. Although we may think voting is very simple, which is actually not the case. Because nowadays, if we are seeing the shareholders' activism, which is actually happening, the impact which is actually coming out of the proxy advisory firms, then you will know what is the shareholder right, how can the shareholders actually change the decision-making process in a company. I'm very sure many of you would have been following up the recent happenings which has been there in the past few years. Into the proxy advisory firms are becoming more active. They are publishing on the governance issue, compliance issue, ESG related, CSR related, all these matters they are bringing out to the shareholders. Although more of the institutional investors, they are guided by the proxy advisory firms. Even the shareholders were there, they are also studying, they are looking into the matter. If you remember, sometime back in Phenolics Cable, 3 of the directors' appointments were actually turned down because of the compliance and the governance issues. Similarly, we have seen in each voters, the reappointment of the managing director with the increased compensation was actually turned down by the shareholders. And there are a lot of issues where the resolution has been rejected in case of the Lupin, in case of the Hero Honda, in case of the Pharma Workcraft. All these cases, we are increasingly actually seeing it. And especially today, what happens, the shareholder activism is becoming more because of the digitalization, because of the e-voting, postal ballot, etc. What happens, more and more people actually participate and they are express, they are voting, they are doing it. Because gone are those days, people used to conduct the AGM in the remote place and pre-selected shareholders used to be there. And they used to get the resolution passed the way it is. Gone are those days. Now everybody is concerned. Every investor, every shareholder, every member, they are interested whether they are investing in the right company. Is the company doing the right thing? Company is governance company, compliance company, whether they are caring for the CSR, whether they are caring for the ESG. All this actually matters today. And then arising out of it, the voting takes place accordingly. So the topic of the voting today is utmost important in the recent past, especially what is happening not only in India, even in globally as well. So with the result, what happens is this topic occurs very, very important, especially it is so in case of the listed entities. Because the listed entities also, there are a lot of things which has actually happened in the recent past. You also might have been following up. I think if I remember in one of the companies, because of the proxy advisory firm's recommendation analysis, I think if I'm not mistaken, it was, I think, Sansera Engineering. They have to actually redraft the DRHV after it has been actually submitted in the draft form. That is what it has happened. And similarly, even the IRCTC, also the same thing has happened in report of the appointment of the directors, etc., and other things are done. So this topic is very, very important. We need to know the integrities inside voting, etc. Today, our presenter is going to be Sakshi, who is going to take us through the insight of various ballot, what is the voting, who are the rights, what are the things, because she will take us through. In fact, when we talk about the voting, it is not only the equity voting, it is also equity shareholder who are having the ordinary voting, and plus we also have the preferential voting, differential voting. Then what about the preferential shareholder? What about the division holder? What about the institutional investors? All these things are all very much important as of today. So that is the topic. Under today's topic, we have our panelist, Mr. Amit Gupta. Amit Gupta is actually not new to us. He has been there in the past. Probably he has done almost about 4 or 5 webinars with us actually. As you know, he is actually a fellow member of the Institute of Company Secretaries of India. And he has been in the practice almost more than about 2.5 decades. And he is a well-informed, well-versatile person on the legal strategic management issues. And he has been actually contributing a lot to the profession. And in fact, he is also delivering the lectures. He has represented the councils of Institute of Company Secretaries of India. He was in the various managing committee. So he has got a versatile experience with his what you call ocean of knowledge. He is actually coming with that. Since he is in the practice, he might have actually seen a lot of things in his practical life, what is happening, what is the thing, and again, the various procedure which are actually involved. So we'll have the benefit of his having the knowledge sharing. I will not go into the detail very much on that. And Mr. Sudhakar, as you know, as usual, our eminent panelist who has been with the leading industry Reliance almost for about nearly 2 decades of the service, and much more than in the earlier companies. And he is also in the board on secretarial standard board, where the secretarial standard 2, which has been actually especially brought out on a general meetings. That means annual general meeting, extraordinary general meeting, other meeting which are actually convened. And he has also come with the versatile experience, and we will have his expert knowledge also sharing. I think with this, I welcome Amit to this program. I'm very sure I'm looking forward to hear from him the various practical insight aspects, etc., and other things and all. I'll ask Mr. Sudhakar to speak a few words and to share his thoughts on the topic. Over to Sudhakar, please.
Yeah. Yeah. Good morning, everyone. In fact, for the last 4 webinars, I'm missing because I was traveling. Right now, I am in Seattle, US. And I thought, let me now onwards, I can join, because for about a month, I was traveling around US and I couldn't join the webinars. And glad to be back to the Mehta webinars. I think, because Amit is the panelist, I think he has now joined. And Amit, good to see you after a long time. I think before I express my views, I think it is fair enough to invite you to speak first. After that, I will take over. Thank you.
Thank you, Sudhakar sir. And it's indeed my pleasure and privilege to be part of this discussion, which is, of course, on very important topic, especially in the backdrop of the shareholder activism, which has started, I'll say, especially in the last half a decade, after especially the e-voting concept and the e-meeting concept has evolved like anything post-COVID. Although prior to that also there was a phenomena, but I think what is being very interesting, if you see the activism consequences, there are voting patterns which suggest that you can't take shareholders for granted, and resolutions might also get defeated, and which is seen on and off. Many prestigious companies are facing those challenges. So it would be a very interesting discussion that we are going to make today to all the panelists and to all the participants. We invite your active participation. You please share your questions, and we would love to deliberate on those aspects. I think with these opening remarks, I'll hand over the baton to Sudhakar sir.
In fact, thank you very much, Amit. In fact, rightly, as you said, I think the very first thing which came, probably, if I'm not mistaken, somewhere in the year 2016, where it has all started with the Tata group of companies. I think Mr. Nestle Wadia has been removed actually initially from one of the company and followed by in the many companies like Tata Steel, Tata Motor, Tata Chemical, etc. and other thing and all. So those will happen, and subsequently we have been seeing many things, very active stuff. Very rightly you have said actually. Over to Sudhakar, please.
Yeah, thank you. In fact, I'm delighted that one of our partners, Nayan Honda, is a panelist today. So, Bala, you have not introduced Nayan Honda. Nayan is also one of the senior partners with about a decade of professional experience and standing in the profession. And she is our Delhi partner. And Nayan, before I speak, I will invite you to express your views also. After that, I will speak. Yeah, Nayan. And are you there?
It is showing actually mute. I'm
Yeah,
not
she's
able
on
to.
mute. Nayan, would you like to say a few things? It doesn't matter. Okay, there might be some issue with her. Okay, coming back to the subject of the day, in fact, apart from the shareholder activism on which Bala, you and Amit have spoke, actually, I want to just go for a brief background and okay, that as we all know, in the past we used to have voting on primarily two things on show of hands and the ballot wherever it is demanded. So then the good olden days we used to have the vote on show of hands more prevalent used to be, and after that, unless until some kind of a shareholders, if they have the capacity to demand a poll, they used to demand, and we used to have the conventional poll. Apart from that thing, I think right from the year 2000 onwards, if I am not wrong, the postal ballot has come. Companies Act 2013, in fact, okay, that for the first time it has brought the electronic voting. Prior to that, there used to be a kind of what's called demand from the shareholders. In fact, I remember that somewhere in the 88 or 90, in one of the regional conference of NIRC, I spoke about the corporate, the what's called as the shareholder governance in the general meeting. So something like that was the topic. When I was speaking about that time I used to say the shareholders always used to complain that though they are the what's called as an part owners of the company, and they are the people who have to take the decisions. But because the general meetings used to take place where the registered office of the company was situated, the shareholders who were across the length and breadth of the country, they were not having the opportunity to participate in the voting process. At the same point of time, though the people who were located in the place where the AGMs used to take place, they were also not able to participate in the voting process because mostly the general meetings, AGMs or EGMs or whatever it is, they used to take place in the working days only, not in the public holidays. Because of that, shareholders virtually have no, okay, virtually the participation is nil, though legally they could participate and vote while taking the decisions, but their participation was virtually negligible. So for the first time, the electronic voting was recognized, and the shareholders have been given an opportunity. Wherever you are in any part of the world, you could have participated in the voting process by virtue of by logging into the whatever okay, the sites and all they are there. And you but in fact, but the only thing was that if I am not wrong, virtually by rule 22, I think rule 20, if I am not wrong, there what happens is the companies were obligated to give the voting, the entire process of the electronic voting in the notice, and that is to be sent by registered post. I remember 2014 when we were sending for the first time. I think we have spent almost 6.5 crores on the posting of the simple that 6 to 7 page notice only, because we were actually in a dilemma that if the notice is a part of the annual report, the entire annual report was to be sent by registered post. So for the first time, what we did was we have separated the notice from the annual report, and we have sent the annual report by an ordinary post and the notice by registered post. Several companies, obviously, even till date also, the notice is to be sent by registered post. Because of that, some crores and crores of rupees are being spent on that. But if you see that though everyone was asking for the electronic voting, if you see how many shareholders are really participating in the electronic voting, in the percentage wise, if you see that, it is really pathetic. I'm sure that Amit and others who are acting as scrutinizers, I don't think even 5 to 6% of the shareholders are participating, because my experience in 2014 or 2015, I don't remember exactly, where we have conducted the electronic voting. That point of time, hardly 2.38% shareholders were participated. So we were thinking that we were asking for the moon, and when we have been given that, we couldn't enjoy that whatever we were asking for. Even today, I'm sure that even in fact, the result, I don't think how much it was encouraged, how much is the I mean, the percentage of electronic voting these days, I am not aware of that. But at one point of time, it was not very encouraging situation. Now, the second part of that is I mean, okay, the scrutinizer's role has increased a lot. Most of the times, it so happened that the practicing company secretaries who act as the scrutinizers, they have to be well versed with the procedures and all. Because now, as Bala and Amit has rightly mentioned, the shareholder activism is increasing day by day. The proxy advisories are also taking active part in that. At the same point of time, the company secretaries too have to understand I mean, especially what the scrutinizer can do, what he cannot do. In addition to that, when the shareholders are demanding the poll, whether the proxy voting will be counted in that or not, there are several legal issues are also there. Sometimes I feel that the company secretaries are not fully geared up. Of course, anyway, as far as the listed companies are concerned, not an issue. I'm talking about the unlisted companies, where it's also that though they are unlisted, but the number of shareholders are much more, not like the minimum number of shareholders. There, the company secretaries have to be very, very careful, because if that voting pattern is challenged tomorrow in the court of law, they have to stand to the scrutiny. So I will give a pause here and now request Sakshi to take over the presentation, and from time to time, we will join in between wherever we have to give our expert views. Thank you.
So good morning, everybody. Today's topic for our discussion on the Masterclass of Companies Act would be an insight into voting. So for that, we'll discuss first what is voting. Here, the word vote has come from a Latin word votum, which means a vow or wish. Voting means formally expressing opinion or wish in response to a proposed decision or as an indication of approval or disapproval of a proposal or candidate for office. At a meeting, voting takes place for both the purpose, expressing opinion in favor or disfavor of a proposal, and choosing a candidate for office. Voting is also known as ascertaining the sense of the House. House means all the members present taken together. Voting is an integral part of a meeting. Every member of an association, company, committee, etc. has his voting rights. Such rights may, however, vary according to some principles. For example, like in a company, preference shareholders may have disproportionate voting rights, while the equity shareholders have proportionate voting rights. Companies Act provides special rules with regard to voting right in respect of shares held by trust. There are different types of votes, and there are different procedures as well as methods of the voting that we will discuss later in the presentation. Sometimes a member loses his voting rights, like if the association in its bylaws may provide that a member who has not paid his subscription for some time shall be debarred from exercising his voting right. Under the definitions provided in Companies Act 2013, voting right means the right of a member of a company to vote in any meeting of the company or by means of postal ballot. Section 47 of the Companies Act 2013 provides that every member of the company having equity share capital have a right to vote on every resolution. Voting right on poll shall be in proportion to the paid up share capital. Preference shareholders also shall get a right to vote in certain situations. Yeah. So the preference
here when you talk,
yeah,
voting right for the members, I think we will also differentiate members and the shareholders. Because what happens is you might have purchased the shares until it is transferred in your name, and the name is entered in the register of member, then only you become the member of the company, then only you get the right to vote. If you are only a shareholder, then you don't get the right of vote. Anyway, nowadays it is a dematerialization in most of the companies, except exempted companies where the physical mode, etc. and all these things, they're likely to be certain delay, etc. and all these things. That is why if you see, the notice is always sent to the members of the company, not to the shareholders of the company. Yeah. Yes, go ahead.
Preference shares are the types of shares that guarantees a fixed rate of dividend to its shareholders and enjoys preference over the equity shares. The
I
preference
think
shareholders,
Ophelia wants to say something. She has raised her hand. Yes, Ophelia, you want to say something? Ophelia? Ophelia, you are there? You raised the hand?
Maybe by mistake, go ahead.
Okay, go ahead.
Yes, sir, it was by mistake. Sorry.
Okay, no problem.
the preference shareholders are only capital lenders for the company and not the owners. Therefore, they do not enjoy the same voting rights as the equity shareholders. While the equity shareholder enjoys the right to vote in every resolution placed before a company, preference shareholders does not have the same rights. Under Section 47, subsection 2 of the Companies Act 2013, preference shareholders can exercise the right of voting only in the situations when the resolutions placed before the company directly affect their rights attached to the preference shares, or the resolution for winding up of the company, or for the repayment or reduction of equity or preference share capital. Further, if the dividend to the preference shareholders is not paid for the period of 2 years or more, such preference shareholders will be entitled to have a right to vote in every resolution placed before the meeting. Here, the proportion of the voting rights of equity shareholders to the voting rights of the preference shareholders shall be in the same proportion as their paid-up capital. Now, we'll understand the
just
difference.
1 minute, Sakshi,
Yeah.
1 minute. Amit, why can't you explain this preference shareholders when they get that right to vote and about the nuances of that? Amit, you may do it.
Yeah,
I'm not
I
going
think,
to
yeah, I think very valid point what Sudhakar sir has raised, because this is one of the most contentious issue when it comes to private limited companies, startups, and the unlisted companies, where large number of investors are subscriber to these preference shares. And many times the battle is fought in the tribunals and in the court on their rights with regard to their voting. Why this question is arising? Because if you go to the background, Section 43 provides that there could be two kind of share capital, one equity and other is preference. Now, what is equity share capital is not defined. It says what is not preference is equity. And preference is defined in a manner that any capital on which the member has a right, rather preferential right to receive the dividend, to participate in the capital repayment at the time of winding up. These are the two characteristics with regard to the preference share capital. Either of the right, if there is, like right to receive dividend or right to receive the proceeds during the winding up process, your capital can be preference. Having said so, if you go to the provisions of Section 47, now 47 says subject to provisions of Section 43 and of course Section 50 subsection 2 and 188(1) with regard to the restrictions on voting right with regard to the related party transaction. It says that every member of a company which is limited by shares, the shareholder will have the right to vote on every resolution which is placed by the company. And his voting right on poll shall be in proportion to the paid up share capital of the company. Here we are parking one point that we will deliberate separately as to, I'm just parking a question, whether private limited company can provide in its article that you may have the voting right on full value, irrespective whether the shares are partly paid or fully paid. Means if your shares are having face value of rupees 10 and you have paid only 5 rupee, can the article provide that no matter whether the shares have been paid up to rupees 5, the voting right will be considered as one share. This issue I am parking because right now we are deliberating on the preference share capital and their voting right. Then it goes on further as to define when the preference shareholder will have a voting right. If you go to section 47, subsection 2, it says that every member of a company limited by share and having a preference share capital will be having a right to vote only on those resolutions which directly affects the rights which are attached to the preference shares. Here it is important to understand as to what is the meaning of directly affects the rights of preference shareholder. Then it also says he will also have a voting right in respect of resolution regarding winding up of a company or repayment or reduction of equity or preference share capital. And of course, the voting right will be in proportion to the proportion in the paid up share capital of the company. So whatever proportion preference share capital is having with regard to the total share capital, their rights will also be in that proportion. So maybe your preference share capital is of different denomination. Maybe let us say you have got the equity shares of rupees 10 each and your preference share capital is of rupees 100 each. Then how you will be making the evaluation of voting rights? So you have to convert that into capital, and then basis of the capital you will be determining as to what will be the voting percentage. The question that we were about to deliberate was as to what are the situations where we are saying that this particular shareholders' rights are affected. When the preference shareholders' rights are getting directly affected, what are the rights of a preference shareholder? We discussed there are primarily three kinds of rights. You have a right to dividend, you have a right to participate in the capital when the winding up is happening, or either of one. Now, if anything which is affecting these rights, so if a proposal is coming that the dividend rate of a preference shareholder is proposed to be changed, or there is a variation of the shareholder's right, or the repayment term is going to be changed, redemption period is going to be changed, conversion terms are going to be changed. These are all situations where the preference shareholders' rights are going to be affected directly. And in those situations, the preference shareholder, no matter whether the dividend has remained unpaid, still the voting right will accrue. Of course, the voting right will also accrue in the situation of winding up because that directly affects their rights. And similarly, if you are going for reduction of capital, that will also be affecting their rights. So in these situations, the preference shareholder has an inherent right with regard to vote. Now, the last situation in which the voting right comes to the preference shareholder, whether it is affecting the right of the preference shareholder directly or not. That means on all items, that is for adoption of balance sheet, that is for reappointment of statutory auditor, all the AGM agenda, no matter, any matter X, Y, Z, if placed before the shareholder, the preference shareholder will get right only in one situation, that the company has not been able to pay, or we can say where the dividend on a preference shares has not been paid for 2 years or more. If you don't pay, it's not question of declaration. We'll understand how the preference shares optics works. As against the principles of declaration of dividend as per section 123, the final dividend is declared by the shareholders, recommended by the board. On recommendation of board, the annual general meeting approves the declaration of dividend, and then it is paid as per the provisions within 5 days, and then transferred to unpaid dividend account, and then so on. And similarly, they have the power that interim dividend may be declared by the board of directors. As against this, the preference dividend is a contractual obligation. Contractual obligations means the board of directors is not under any obligation or requirement to hold a board meeting, declare a preference dividend, because that is already contractually agreed between the preference shareholder and the company, that I will pay you dividend on so and so date or at so and so rate. Maybe it is 6% coupon. So 6% every year I'll pay you. Now, $1 million question on which the fight is there, on which the debate is there, that is on 2-3 points. First point is as to whether a preference shareholder has got right with regard to dividend or not. Second question, when he has got that right, what is the date on which he will get that right to vote on the items, on any of the items what are mentioned into the provisions, that is 47 subsection 2 proviso 2, as per that, on the all items, when he will get that right. So if you see, as we were discussing, as against the principles of dividend on equity, the preference dividend is not required to be declared. So unless contrary is agreed in terms of the issuance of the preference securities, or unless contrary is provided in your articles, the dividend on preference share becomes due on the very first day of completion of tenure of 1 year. If say dividend at the rate of 6% is payable and the preference share was issued on 1st April 2023. So your first year term will complete on 31st March 2024. The dividend will be due on 1st of April 2024. If you don't pay on 1st of April 2024, your 1 year default has started. Now, second year dividend will become due on 1st of April 2025. So if you don't pay on 1st of April 2025, all your voting right accrues on that very day, that is 1st April 2025. That means all agenda items which are tabled before the members on or after this date, the voting right of a preference shareholder also has to be taken into account. And not only that, the company secretary and the compliance team, when is sending the notice to the members, they have to ensure that not only notice goes to the preference shareholder, but it also very clearly mentions that the preference shareholder has a right to vote on these agenda items. as far as this voting right concept is concerned with regard to the preference share. I hope I am able to make clear as to how the reckoning of dividend is done, how the default is to be calculated, and how the period of 2 years has to be calculated with regard to provisions of section 47. Maybe we can, there are a couple of more points. If Sudhakar sir, you permit, I'll take another 2 minutes to explain those also in stretch.
Yeah, please go ahead.
So there is one more provision. When we are working on an assignment for a private limited company or the startups, basically, they keeps asking that you create a mechanism by which I get the money from a preference shareholder, but I don't want this voting right to be triggered, because this is something we don't want, because preference shareholder may be investing, let's say, almost 100 times the money what I had invested. My equity share capital may be 1 crore, but I am taking 50 crore from the preference shareholder. Now, if preference shareholder at any point of time, if gets a voting right, the equity holder voting rights are going to be minuscule. So the preference shareholder will get a right to overtake their company at any point of time, which they don't want. So what is the mechanism? The mechanism is provided in the section 47, read with section 43 itself. If you recall the 5th June 2015 notification issued by the Ministry of Corporate Affairs under section 462 of the Companies Act, which says the provisions of section 43 and 47 are not applicable on a private limited company. What does that mean? Essentially, for 43, there could be another class of capital also. That means other than equity and preference, though so far we have not been able to find out any other instrument in the market, but law envisaged by giving this exemption that there could be a third class of capital also, maybe though theoretically. But 47 is very interesting, because 47(2), proviso 2, which gives a voting right to the preference shareholder on non-payment of dividend for 2 years, is also ousted if you make a specific mention in your articles of association. Not only that, the general right with regard to the rights of preference shareholder, which directly are affected or winding up, even these provisions can also be taken away by suitable provisions in your article. It is not just that you are not mentioning anything in your article and you will be saying that I am, because a private limited company, I will be entitled to waive the voting right of a preference shareholder. Answer is no. You have to have a specific provision in your article saying that the preference shareholder will not have, notwithstanding anything contained in the provisions of section 47 or any other applicable provisions of law, irrespective of the fact that dividend has remained unpaid for any period of time, the preference shareholder or so and so class of preference shareholder will not have any voting right. If these kind of provisions are there, then even you can overcome the challenges with regard to the voting right which are accruing to the preference shareholder in case of a private limited company only, not in respect of any other company. I think with this, I can take a pause, and maybe we can invite the discussion on this, and maybe the other panelists can also share their thoughts on this preference share subject. I think this is very, very interesting.
I think, Amit, you have very elaborately discussed about this one. I think now we should move ahead, because there is a lot of slides are there. Let us not stick to this preference shareholders thing only. But the only thing is, for the benefit of the participants, they must know one thing, that whenever you are conducting the EGM and whenever you are calculating your voting rights, in case you have preference shares, you have to be careful. You have to see that whether by any chance they're acquiring the voting rights. If it is so, how to reckon the voting rights, as Amit has very lucidly explained, that is to be complied with, number one. Number two, I'm not very sure whether in the previous, last webinar, which was there on the general meetings, this issue was discussed or not. Some company secretaries, and despite the fact they have preference shares, especially in case of closely held companies, they don't circulate the annual report to the preference shareholders, which is very, very important. As secretarial auditors and as a company secretaries in service also, please keep this aspect in mind, that you have to ensure that the annual report is sent to all the members of the company. Though the preference shareholders may not be having the voting right, but they have the right to receive the annual report of the company.
Yeah,
In
this was
addition to that,
discussed, Sudhakar, last time.
okay, fine.
And it was
fine.
also said, as you rightly said, yes, they are being a member, they have the right to receive the document, but they don't have the right to vote in the meeting. Yeah.
Excellent. Then it is fine. Okay, Sakshi, please go ahead further.
Now, differential voting rights. Section 43 of the Companies Act 2013, read with the Company's Share Capital and Debenture Rules 2014, describes the equity share capital with differential rights as to dividend, voting, or otherwise. The shares with differential voting rights provide the shareholders with differential rights relating to voting, that is either more voting rights or less voting rights compared to ordinary shareholders of the company. The equity share capital contains this class of equity shares with differential rights relating to voting power and dividend. There are two types of DVRs: shares with superior voting rights, shares with inferior voting rights. The shares with less or inferior voting rights carry higher dividends, whereas the shares with superior voting rights carry lesser dividend rates. Like, the voting rights can be in the ratio of 2:1, that is 2 votes for 1 share, or in the ratio of 10:1, 10 votes for 1 share. DVRs enables the promoters to retain substantial control in the company. Sometimes in the case where the in the case of startups, they lose the control of the company while they dilute their equity shareholding. So in that situation, having the equity with DVRs can help the promoters of the startups to gain the control over their company. Issue of shares with DVR would not exceed 74% of total voting power at any point in time. Earlier, the limit of DVR was set at 26%, but the amendment increased the limit. Now, types of voting. Voting can be of 4 types, out of which the first we're going to discuss is the voting by show of hands. It is described under Section 107 of the Companies Act 2013. The voting in the first instance shall be done by display, show of hands, unless a poll is demanded or voting is to be carried out electronically. A poll can be demanded without going through the formality of show of hands. And in the voting by show of hands, each investor gets only 1 vote, irrespective of shares held by him. The chairman of the meeting shall take the voting by way of show of hands at the first instance on any resolution. He is required to seek choice of the members present for and then against the resolution. The number of members voting for either side shall be counted and noted by the chairman. He may direct the CS to do the same as well. Chairman, after ensuring that there is no demand for the poll, shall declare the outcome of the resolution, whether the same was passed or failed to be passed. Declaration of results of the resolution, along with including process of proceedings of the meeting, are required to be entered in the minutes of the general meeting. Said result shall be said to be conclusive evidence of the fact that the resolution was passed or otherwise. A proxy cannot vote on the show of hands.
Actually, Sudhakar was saying initially about the voting. Much before the digitalization, much before the e-voting, much before the digitalization took place, the shareholders meeting used to be conducted only by physical meetings. And there were a lot of companies, they want to get the resolution passed what the company board of directors, they wanted to have it. Because of that, deliberately, they used to have their registered office in a remote place where the people cannot that easily reach, and they conduct the meeting at that particular place. In fact, I know some of the companies, they were actually struggling to give the minimum number of the people's presence in that meeting because some of the employees were allotted the share. They used to pick up the employees from their shareholders to make the quorum for the meeting, and they used to take them. And then they used to get the resolution passed because they are all prevented. There was a lot of, mismanagement has been happening in this case. Generally, what happens is many people do not attend the meetings because of the faraway places. Number two, the remote places, the question is actually ruled out. So any resolution which is proposed the chairman, we have number of people who are present, majority of them vote raise their hands, the resolution is set to passed. That is what it has happened. Now, after the digitalization, after the e-voting, etc., a lot of things have changed. Although Sudhakar also did mention that considerably participation is actually less, but it is definitely picking up. And shareholders' activism is becoming more and more, especially the playment of the institutional proxy advisors and the institutional proxy voting pattern, which is actually changing. Many things are actually nowadays happening. So one thing is that the show of hands now has not much of the validity unless until maybe in the private limited company, closely held public limited companies, etc., it still continued to be there. Otherwise, especially when it's come to the larger companies, listed companies, etc., the digitalization in ongoing, it is going to be very shareholders activism. The company's decision-making process will undergo a drastic change. Amit, your experience?
I think it's not there.
Is not there. Yeah.
Chalo, Sakshi.
Yes, Sakshi, go ahead.
The second type of voting is the voting by poll, which has been explained in Section 109 of the Companies Act 2013. A poll may be demanded by the members if the numbers of members present and voting have not less than 1/10 of the total voting power or shareholding of not less than 5 lakh rupees or higher. Chairman of the meeting shall appoint the person or more person to scrutinize the poll process and votes given on the poll and to report thereon to him. The demand for a poll may be withdrawn at any time by the persons who made the demand. Chairman of the meeting have power to regulate the manner in which the poll shall be taken. The third type of voting is the voting by postal ballot, which has been explained in Section 110 of the Companies Act 2013. It includes voting by shareholders through postal or electronic mode instead of voting personally for transacting business in a general meeting. Each item proposed to be passed shall be in the form of a resolution and shall be accompanied by an explanatory statement. A company shall send notice and draft resolution by registered post to all the shareholders, explaining the reason in writing on a postal ballot. If a resolution is assented to by the requisite majority of the shareholders by means of postal ballot, it shall be deemed to have been duly passed at a general meeting convened in that behalf. Result of the postal ballot shall be declared along with the scrutinizer's report within 7 days of the last date of receipt of postal ballot. Voting by electronic means is the fourth type of voting, which has been explained under Section 108 of the Companies Act. It includes remote e-voting as well. Every listed company or a company which has more than 1,000 shareholders is required to give the option of e-voting to its shareholders. Notice of the meeting shall clearly mention that the business may be transacted through electronic voting system and the company is providing facility for voting by electronic means. Notice shall clearly indicate the process and manner for voting by electronic means and the time schedule, including the time period during which the votes may be cast and shall also provide the login ID and create a facility for generating password and for keeping security and casting of vote in a secure manner. E-voting shall remain open for at least 1 day, but not more than 3 days. E-voting will be available to the shareholders holding shares in physical form as well as the demat form. Once the vote on a resolution is cast by the shareholder, he shall not be allowed to change it subsequently. At the end of the voting period, the portal where votes are cast shall forthwith be blocked. The scrutinizer shall, within a period of not exceeding 3 working days from the conclusion of e-voting period, unblock the votes in the presence of at least 2 witnesses and make a scrutinizer's report on the votes cast in favor or against, if any, forthwith to the chairman. The resolution shall be deemed to be passed on the date of the relevant general meeting of members. In case of joint shareholding, e-voting option shall be available only to the first shareholder. Member may participate in the general meeting even after exercising his right to vote through remote e-voting, but shall not be allowed to vote again. In the case of the listed entities, along with the procedure of e-voting explained in Companies Act 2013, they are required to comply with the provisions of SEBI LODR as well in this regard. Now, scrutinizer. Scrutinizer is a person who observes carefully the whole process of voting on behalf of the company in an independent manner. A scrutinizer monitors the entire process of e-voting, polling, and postal ballot done in the general meeting. As per Companies Act 2013, following persons can be appointed as a scrutinizer: chartered accountant in practice, or a cost accountant in practice, or a company secretary in practice, or an advocate, or any other person who is not in employment of the company and is a person of repute, who in the opinion of the board can scrutinize the voting process in a fair and transparent manner. The scrutinizer shall be appointed by the board of directors of the company. Prior consent to act as a scrutinizer shall be obtained from the scrutinizer. Scrutinizer shall provide a compiled report of the voting results of all the resolutions proposed in the meeting. Along with the scrutinizer, the report shall be signed by the chairman of the meeting as well. The scrutinizer shall maintain a register, either manually or electronically, to record the assent or dissent received, mentioning the particulars of name, address, folio number, or client ID of the shareholders, number of shares held by them, nominal value of such shares, and whether the shares have differential voting rights. The register and all other papers relating to electronic voting shall remain in the safe custody of the scrutinizer until the chairman considers, approves, and signs the minutes, and thereafter the scrutinizer shall return the register and other related papers to the company.
Okay, just
No.
wait, Sakshi,
Yeah.
wait. Amit, as a practicing company secretary, would you like to advise the participants who are the practicing company secretaries whenever they are acting scrutinizers, which are the points they have to, I mean, of course, the procedural part, everybody knows that, but with your experience, any kind of advices or cautionary precautions, what they have to take, would you like to advise them?
Yeah, certainly. If I can say from starting point, first point that the scrutinizer somewhere is confirming that as to confirmation regarding the dispatches of the notice convening the general meeting. Now, in one of the para, we are mentioning that notice to so and so number of members was dispatched through this mode by email to this number of people, by registered post, speed post by this number of people. So that is one thing which we need to verify before we move to the issuance of the report. Then second thing is with regard to the attendance. Generally, we ignore these small things as to who were present during the meeting. So there is a report which is received from the e-voting agency who is conducting e-meeting also. They will be providing you the list of people who joined at what point of time and who exited at what point of time. So basis that you can check the time when the meeting was commenced, the quorum was present, A. B, the necessary number of people who were forming quorum, they were present all the time when the agenda items were taken up. Third thing, which we are required to see very carefully, in case of a non-individual shareholder, usually we have seen whether it is a body corporate, whether it is a institution, whether it is a bank, whether it is any person who is a non-individual, as per the provisions of law, the mandatory requirement is the voting supported by a resolution duly passed at their meeting. And many a times we have seen that though voting is there, but their supporting resolution is missing. And many a times we are not in a position to take a call. Maybe your situation is like your resolution may gets defeated if you are ignoring those particular aspects. So how to deal with those very situation is really very tricky. Can we reach out to those institutions that we are scrutinizer to this matter and we have noted, and that's what we have been doing, because if somebody has voted, I am duty bound to check with him. Maybe he has uploaded, the copy is not visible to me because of the technical glitches. B, there may be inadvertent error on his part because he may have the option. Generally, we are mentioning in the notice that you may send the resolution copy through email also, and maybe it is remaining undelivered or due to some technical error, it is not appearing. So what we are following is while we are taking note of the voting pattern, and we are verifying if we are finding that there are certain institution or certain corporates who have voted, but their supporting resolution is missing, we sent an email giving a confirmation that we have found that you have participated in so and so voting. However, supporting resolution is not there. If you want to provide, otherwise we will be ignoring as if you have not voted. Now, these kind of
Amit, 1 minute here. See, this is the point of contention. You see that as a scrutinizer, if I am the scrutinizer, when I have opened the what's called as
voting.
the voting portal, that point of time, whoever have established their authority to cast the vote, if I am not having that particular resolutions or power of attorneys or whatever it is received by me or by the company, I will reject that particular vote. I am not going to talk to that particular shareholder. Look, I have not received your authority, resolution, and all these things. Please send me now. No, not at all. Because I have a very limited time available with me, number one. Number two, if you see in the voting instructions, when we are sending the notice, we very clearly write that while casting the vote, it is their responsibility to ensure that whatever the authority they have to submit either to the scrutinizer or to the company directly by, they can upload it on the voting portal, or alternately they can send it by email also. But I'm not going to communicate. Recently, one of the practicing company secretary asked me about this question, that I am the scrutinizer. I have not received this thing. Am I duty bound to check with the shareholder by whether you have the authority or not? I said, by no means you have that particular, you are not under obligation to do that. Yeah. Bala, you may also.
I fairly agree to the same. Why I was saying, because we have checked with the various depositories also, and the practices are so very different in respect of depository allowing the voting. So when depository opens your login ID, when allows you to log in through the corporate ID, then they take all the resolutions for the purpose of authentication. So many a times, if I am a, let's say, ABC Limited, and I want to create my corporate login, I will be providing the resolution copies to my depository for allowing my login ID to operate. So maybe I have provided that detail to the depository, and it is not appearing in the e-voting portal. So for that reason, we have been doing. I fairly agree your point on the legal point. Balaji, Bala sir, you may please go ahead.
I think both Sudhagar and as well as you, both you are saying is absolutely correct. Because I also been in touch with many of the people who have been acting exclusively the scrutinizers. Now what happens is here, as Amit puts correctly, it is actually from the depository who is allowing him either NSDL, CDSL, most of the thing, although private platforms are there, it is basically CDSL, which is very popular, and NSDL platform, they are voting it. It is basically depository is actually getting the things and they check the authority that they have the authority to vote. They are actually permitting. Due to some reason or other technical reasons, things are not visible and available and all those things which are actually there. Although as per the law, we are not duty bound to run the check, etc. and other thing and all, follow with the things. But because of this technical reason, etc. and also thing in practice, I'm coming to the word in practice, we are actually tend to do that. That is what it is happening with many of the scrutinizers, according to me also. Sudhagar, you are
Because,
absolutely right. As per the
see,
law,
because
you are right. You have
Bala,
7 days time.
the thing is 7 days time only for the, in case of listed companies, within 3 days of the closure of the meeting, I think the scrutinizer has
48
to
hours.
submit the
Yeah,
report.
48 hours, sir.
Yeah,
48
48
hours.
hours.
48 hours.
So you have very less time. In the 48 hours, are you going to talk to these people? So
100%,
there the question is,
100% I'm in agreement with you.
Only point why I consider that it may be thought, it may be given a thought, we may deliberate, because somebody has exercised his right and he has voted, and your voting pattern is also showing his name. Now to deny whether maybe there is a small glitch which is not allowing me to see his resolution. Before concluding that his vote has to be negated, I think I need to have something more.
what I'm trying to say, Amit, is only one thing, it is the responsibility of the company also to satisfy the scrutinizer. It is not for the scrutinizer to struggle with all these things. What I'm trying to say, Amit, is that is it the responsibility of the scrutinizer to struggle with all these things?
Legally
Or
not.
is it the responsibility of the company to do that? That is what my precise question is.
I agree, sir. Fair point.
Sudhagar, legally you are absolutely correct. I have no doubt about it. Because the notice clearly says authority has to be there, it has to be given, everything is there. You are absolutely correct, there is nothing. But really speaking, yeah, we can actually say nobody can actually challenge us in that. But practically what happens is because of the glitches, as Amit puts it, sometime due to some reason or something, we are not able to see it and other things which is happening. That is why they want to give the right perspective. That is why they are running a check. Many
So what
people
I'm
are not
trying
doing
to,
that.
what I'm trying to say, Bala, here is, and Amit, you also please, I mean, okay, if you may agree with me, what I'm trying to say is, whenever we are in these kind of webinars, we have to discuss first what is the legalities. Second thing is the practical aspects. Practical aspects, for a moment, I will keep it aside. The reason being, as I was repeatedly mentioning, that we have 48 hours time. I'm under obligation to submit my report within 48 hours. So what will happen is by that I have to put a cutoff date, a cutoff time to the company. Within this time, if I am convinced that he got the authority, I will allow the vote. Otherwise, I will take the vote as invalid, and then I will go ahead with my this thing. I think that is what the legality is concerned about, because sometimes it may so happen any of the participants might be the scrutinizers, they might be facing this kind of an issue. That point of time, no doubt about it, that pragmatic view, what we take is slightly different to that of what is the legality. That first to understand, we have to legality. And the second thing is, no doubt about it, I will also say that we have to also take pragmatic view, but not the pragmatic view at the cost of my scrutinizer position. That's what I'm trying to say.
Correct. 100% you are right. 100% you are right actually, but the only thing is within the 48 hours, the things are not happening. Then as you rightly say, sorry, I don't take the vote. That's it.
Yeah, I think so. There are some questions. There are some questions.
Any
I think,
participants are there, their experience they can share on this issue? Any
Bala,
participants,
there are some
please?
questions. Why can't we take it? See, if you allow that again, if
Okay, no
anybody wants
problem.
to speak and
Yeah.
all, it may go for a toss. Why can't
Okay,
you
no
take up
problem.
some questions now?
Okay, we'll take a questions.
Yeah.
Okay. With the coming into practice of conducting the general meeting by the VCM, the shareholders are deprived of the right of votes to a resolution by suggesting a modification to the resolution. They have the right to say yes or no only. Your views, please.
Yeah, that is correct, because see, what is happening is, see, you can pass a motion for modification or amendment of the resolution only at the meeting. But in case of electronic voting, what is happening is by the time the meeting starts, your electronic voting is closed, that remote e-voting is closed. So because of that, you cannot do any kind of modification. That's why, in fact, you may find a lot of resolutions when they're proposing in case of electronic voting scenario, the wordings with or without modification is more or less removed now. Though some companies, they do put with or without modification, only to ensure by any chance if any amendment or anything comes in between, and also that to have the leverage only they put it, but otherwise in case of electronic voting, no possibility of any kind of modifications at all.
Where there is only one shareholder who holds 26% and intentionally block the special resolution, hampering the business of the company. What is the remedy available to the remaining 74% of the shareholders?
See, if there is a, the only thing is, in this case, what happens is that 26%, that magical numerical of 26% is always the person who has invested that much money. He has to have a safeguard. So he will be definitely, his view is to be taken into account while taking the decisions. Okay. That is the reason that 26% comes. Now, if unfairly that person is blocking the resolutions and is not allowing the business to go ahead, it means there is a litigation is there. So obviously you have to go to the tribunal and all, and maybe under the cause of oppression kind of thing, you have to go ahead with that.
Yeah, only option available is the NCLT.
Correct. There is no other option.
That's right. Does the issue of the additional preferred share ranking pari passu with the existing preferred shares rights to the existing preferred shareholder, and can they vote on such an agenda then? I think Amit has already replied, I think so, on this question.
Yeah. Correct. Next.
Oppression by the minority, remedy under O&M.
Oppression on the minority, again the same thing, you have to go for the NCLT only.
Okay.
Yeah.
In a 50-50 JV company, if A Limited and B Limited were during the AGM, second shareholder B Limited shareholding holding only 20% share participates in the AGM. Question is, can a special resolution be passed in case of the voting by show of hands or demanded? Only assuming 5 members are personally present.
And what is the question? Come back again, Bala.
There are two companies, 50-50
Yes.
shareholders, A and B. During the
No,
AGM,
1 minute. You meant to say there are only two shareholders in the company.
A JV company, A and B Limited.
And A and B Limited. So there are 50-50% shareholders.
50-50.
Okay.
And second shareholder, B Limited, shareholder holding only 20% of the share. He participates in the AGM. Question.
No, but you said no, but you said 50-50% joint venture.
Then I don't know how the five people are present, she is saying.
No, 5 people present, it is okay. Suppose, for example, in case of a joint venture, if it is a limited company and 50-50% joint venture, then what will happen is that you have to have minimum number of shareholders, right?
But so the thing is here, she's saying B Limited is only 20% share.
This I couldn't understand that.
There also I get a confusion. I don't know. Because here says 50-50 in the top line. and holding only 20%. That means it cannot be 50-50. It is actually,
Yeah.
it could be only 60, is 80-20.
Yeah.
Anyway, the question is, can a special resolution be passed in a case of voting by show of hands if demanded, assuming 5 members are personally present?
See, vote on show of hands, whether it is a special resolution or an ordinary resolution. Okay, if it is not a listed company, then the first difference is the vote on show of hands. So that point of time also you have to ensure that 76% voting is required, okay, for passing that special resolution. And I mean, the 3/4 of the voting capital is to be approve that resolution for special resolution. Suppose if they demand a poll, then only the ballot will come. Otherwise, vote on show of hands also you can pass the special resolution. What is the problem?
Because in case of the show of the hands, majority who voted for the special resolution should be 2/3, then the people not voted. That is the condition is there actually.
Correct.
But unless
Definitely.
until you have other conditions, in terms of the value, in terms of things, those conditions are not present, I think this can be done.
Yeah.
Whether public limited company have the article restricting the redemption of the preference share held by promoter, I think this also Amit has replied actually. Should we check the Ben pass for checking the voting authority?
In the ban post, how you will get the voting authority? In the ban post, you will get simply from the exchanges the okay, the number of shareholders, and then what is the how many shares they're having it.
Correct. Authority cannot be checked. The authority has to come by a resolution which is submitted with a separate document.
So Ben post doesn't talk about even the voting rights also. Who got the voting right, who doesn't have the voting right. Ben post doesn't talk about that. Say, for example, if the subsidiary companies are holding the shares of the holding company, they don't have the voting right there. Okay. But Ben post doesn't talk about that. Ben post merely talks about that how many shares that
Correct.
shareholders are having. That's it.
Yeah, that's all. It gives a list of the beneficial shareholder. That's all, nothing else.
In fact, Bala, that recently somebody asked me one more question also. Whenever the electronic voting takes place, if a body corporate is participating in that, can he give a standing resolution that by in future also the same resolution is to be taken to take my authority? The answer to that is no, because every year, whenever he is participating in the voting, he has to upload that resolution or power of attorney. He cannot say, okay, you keep this thing in your records and then do it. If it is suppose if somebody is having a power of attorney on behalf of the shareholder to participate, to vote on his behalf or to sell or buy the shares and that kind of a thing is there. If that power of attorney is registered with the company, and of course, yes, otherwise, no.
I think that is all the questions we have.
Okay, Sakshi, go ahead.
Sakshi, move forward.
There are certain restrictions as well on the voting rights, which is explained in the section 106 of the Companies Act 2013. Companies' articles of association may restrict the shareholders from exercising their voting rights in respect of any shares registered under his name on which a sum payable and it has not been paid by him, or if the company has exercised any right of lien. Voting right of the shareholders cannot be restricted in the situations other than the mentioned above. Now, there are certain points which are explained in the Secretarial Standards on General Meeting as well relating to the voting rights. A member who is a related party is not entitled to vote on such a resolution in which such member is a related party, except in case of a company in which 90% or more members in number are relative of promoters or are related parties. In case of wholly owned subsidiary, the resolution passed by the holding company shall be sufficient for the purpose of entering into the transactions between wholly owned subsidiary and the holding company. In case of a private company, a member who is a related party is entitled to vote on such resolution. The cutoff date for determining the members who are entitled to vote through remote e-voting or voting at the meeting shall be the date not earlier than 7 days prior to the date fixed for the meeting. Only members as on the cutoff date who have not exercised their voting rights through remote e-voting shall be entitled to vote at the meeting. Proxy. A member of a company entitled to attend the meeting and vote at the meeting shall have a right to appoint another person as a proxy to attend and vote at the meeting on his behalf. Proxy shall have not any right to speak at the meeting and shall have right to vote except on a poll. Proxy form shall be in the form MGT 11. Proxy form duly filled, stamped and signed is valid only for the meeting to which it relates, including any adjournment. In case of a body corporate, a person shall be authorized by its vote to attend and vote at the general meeting. A proxy need not to be a member of the company.
Just go back 1 minute,
Yes.
Sakshi. See that in case of general meetings and in case of voting, proxy plays a very important role. And because that 48 hours before, the proxies are to be lodged with the company 48 hours before the meeting. And please note that this is a right available to the shareholders given by the Companies Act itself. So this right cannot be taken back. That is the primary reason. If you see in case of SS2, the question, in fact, which we have dealt with in that very elaborately is, can we conduct the general meetings at a shorter notice? Answer is yes, you can conduct the general meetings at a shorter notice. Otherwise, you have to give that 21 days clear notice is to be given. And sometimes the question has come that in case of JV companies, especially, I have the board meeting in the morning, and after a couple of hours, I will hold the general meeting. Can I, whether it is AGM or EGM or whatever it may be? Is it possible?
Do you have 100% acceptance?
That is the only question, Bala.
If you have 100% acceptance, you can do so.
Yes, if you have 100% acceptance, you can do so. If you don't have the 100%, you can't do so, because though under the Companies Act it says that 95% with the 95% consent you can hold the meeting at a shorter notice, but at that point of time you have to give that 48 hours time for the lodgement of the proxies. If you have 100%, then only it can be done. If you see the SS2 prior to 1st October 2017 and post October 1st October 2017, the revised SS2 has come. This is the major difference. You people will find that. That is very, very important.
Absolutely, I agree with you, Sudhakar. It's a very finer points actually. If you have the 100%, yes, you can. If you have anything less than that, you need to allow that proxy lodging time, you need to build it. That is very clear. Yeah.
Similarly, whenever there is a kind of conflict among the shareholders while holding the general meetings, in fact, in the good olden days, we used to have a proxy wars also. So the lodgement of the proxies, the validity of the proxies is very, very important. And of late, the what's called as the amount of importance what the proxies are to be given, it is coming down over a period of time, especially in case of this post-COVID, the proxies appointment is not there altogether, it has been removed. So my fear is that company secretaries should not be oblivion about the proxy related provisions. It's already 5 years we are having this virtual general meetings. Why I'm saying this thing is one of the rights this shareholder is having is he can inspect the proxies of lodged with the company. Several times what happens is that the people who come to inspect the proxies, they ask the company secretary for the proxy register. In fact, proxy register is to be prepared 1 day before the general meeting. And in the proxy register, you have to give whatever the columns are prescribed. And you have to also say how many proxies are valid, how many proxies are invalid. If the proxies are invalid, for what reason the proxies are invalid, everything is to be given in the proxy register. So the people who come with ill intentions, what normally they do is they ask the company secretaries for the proxy register. My advice to the participants is please note that the shareholders have the right to inspect the proxies, but they don't have the right to inspect the proxy register. You are well within your rights to refuse to give the proxy register for inspection. You give all the proxies, there may be hundreds of proxies might have been lodged with large companies. Let them scrutinize, inspect the proxies. Let them do whatever they want. At the same point of time, let me also say, in one of the Reliance general meetings, there was one shareholder who was while inspecting the proxies, he started taking the photographs with his mobile. That point of time, I have objected to that, and he said, "What right you have to object?" I said, "Look, you can inspect the proxies, you can register, note. I will give you the white papers. You can note whatever you want, but you cannot take even photographs of that proxies also, you know. Because sometimes it may so happen the proxies are very, very important. Similarly, the authenticity of the proxy, the validity of the proxy, because proxy is having a right to demand a poll. Proxy, though he cannot what's called as speak at the meeting, but he can definitely ask for a poll, provided he got that kind of what's called he's representing that amount of the number of shares, that 5 lakhs or 10%, whatever it is, whichever is higher sided. So these are a few niceties as far as the proxies are concerned. I thought of bringing to the notice of the participants. Yeah. Yes, Sakshi, please go ahead.
Not only that, Sudhakar, I had one experience. What happens is in a particular general meeting, there are 3 people who had come as a proxy. Then when the 3 people have come as a proxy, I rejected 2 people. I allowed only 1 person. Then they started fighting with me. They started telling me, no, how can you say we are holding a proxy? You have this, I got a copy, whatnot, another thing. Then at that point of time, as you rightly say, I had a proxy register made up, which is maintained. I have received the proxies in favor of all the 3 people, but only thing is the date was different. The person to whom allowed was the last proxy issued by him.
Correct.
So that was the reason I was able to convince him, look, this is what it is. That is what it has happened.
In fact, not only that, suppose if a person lodged the proxy and is not, suppose in your case, you have the dates. Suppose if the dates are not there, then which one you will take it? We can reject all the 3 proxies also. We are well within
either I have option to reject all the proxy, it is invalid on the prima facie because it is not dated, or otherwise I can put the time it is received. I may decide to allow what I received last.
Correct. I agree.
Otherwise, prima facie, I can reject everything because it is undated.
Yeah, correct. Yeah. And similarly, on the proxy, they have to even put that stamp also. Sometimes people, they don't put the stamp, but most of the times what happens is because of the pragmatic view, again, the companies themselves put the stamp and then they cancel that and all.
I used to carry the stamp with me whenever it is coming unstamped. I used to put the stamp and cancel it.
Yeah, but technically you can reject that proxy if it is not stamped properly.
That is right.
So these are all certain niceties.
But somehow we have been following this practice. But I think they should remove that from even today. That stamping procedure is actually there.
See, in fact, you are talking about the proxy. According to me, this registered post business is to be also stopped because now it is almost a decade after Companies Act 2013 has come. People are familiarized with the electronic voting. What we could have done is simply put down the website of the company and then also put it elaborately in the notice. But this registered post or speed post business should be stopped, according to me, because unnecessarily companies are spending crores and crores of rupees where they have lakhs and lakhs of shareholders, and the output is not in proportion with the amount of money what the companies are paying in. But anyway, that is a different discussion altogether.
There is one question has come actually. Can a foreign holding company having an authorized representative, a foreign national, can appoint an individual, Indian national, Indian director as a proxy in India to attend the votes in the general meeting in an Indian subsidiary company. The Indian National Indian Director will not be an authorized representative, but only a proxy for a general meeting. Please guide.
Yeah, see, in case if a foreign holding company is authorizing somebody to attend the meeting or to appoint a proxy on his behalf, it all depend upon what sort of authorization that person has been given. If while authorizing the person, if the resolution is passed by the foreign, whichever is the company having the shares, if they authorize a person to attend the meeting, that person is also having, whether he can attend himself or he got a right to appoint the proxy. He can appoint the proxy. That proxy will be treated as a proxy only. He will not be counted for the purpose of quorum. However, the person who has been authorized by the board of that foreign company, if he attends the meeting, he will be taken as a representative of the company and he will be counted for the purpose of quorum also.
Somebody has actually replied, it's acceptable practice to facilitate the voting by a foreign holding company in the Indian subsidiary.
No, see that, let us all, always it is very important about the legalities as I was mentioning. If a company, whether it is a company or a body corporate, if they are authorizing a person by virtue of a board resolution, he will be representing the company and he will be counted for the purpose of the quorum when he is attending the meeting.
Correct, absolutely right.
And he got a right attend in person or he can appoint a proxy. If he is appointing a proxy and the proxy is attending the meeting, then he will not be counted for the purpose of quorum.
Correct. He'll be simply a proxy only. Yeah.
Correct.
Yes, Sakshi, go ahead.
So, in the event of equality of votes, whether on show of hands or electronically or on a poll, if only the articles of the company provides, then the chairman of the meeting shall have a casting vote. Where the chairman has interested and conducted of where the chairman has interested the conduct
I think Sakshi said
where the chair
yeah, I think Sakshi, you are frozen for about a couple of minutes. I think you have to repeat.
yeah, okay. So, where the chairman has interested the conduct of proceedings in respect of an item in which he is interested to any non-interested director or to a member, a person whoso takes the chair shall have a second or casting vote.
Okay.
Thank you.
Somebody has asked the question, can a proxy be counted for the quorum in a private limited company by altering the article of association?
Articles of association cannot override the Companies Act.
I think probably you are right, absolutely. But I think the companies where, they don't have the share capital, they may enforce the member to appoint a proxy who will be actually allowed to speak and vote. I think so. This was a provision in the earlier act. I don't know about the current act. You can update
To
me
my
on
knowledge, proxy cannot be counted for the purpose of quorum number one.
this.
And he has no legal right even to speak at the meeting. But however, the chairman has a right to allow the proxy to speak at the meeting if he feels so. That is possible.
Because earlier act this was there. That is the company where they don't have the share capital. So in such a cases, the member may appoint a person who can actually vote. Something like that. It was there actually here. Amit, your view?
Yeah, if I can be allowed for a private limited company, because these provisions by virtue of 5th June 2015 notification have been exempted for a private limited company by way of specific insertion in the article. So if my article says that a proxy can be counted for the purpose of voting or for any other means, right? I think there is no restriction, but there has to be a specific provision by virtue that the provision will not be applicable. The provisions of so and so section will not be applicable. You don't get any specific privilege. The privilege will come only when your article specifically say that proxy will be counted for the purpose of quorum. Then only it will come, otherwise no.
So
And
that
how
means
about
it
vote
is,
on show of hands, Amit?
Sorry?
Vote on show of hands also he can do it?
Vote on shares also we can do.
No, no, vote on show of hands.
Vote on show of hand, yeah. Means proxy can be allowed to vote on show of hand, provided you have a specific carve out in your article. Because in case of a private limited company, it is a very, you can
Yeah, I
say,
got it.
so you can agree anything in between. And when the law has specifically allowed you to give a carve out, I don't think
Okay.
should there be a problem.
so that
Oh.
means in short, just because the private limited company, you cannot do it unless you built in these things in the article of association, very
Absolutely.
categorically spelling out.
Yeah,
Okay.
absolutely.
Okay. So the answer is yes, it can be done provided if it is there in the article of association. Yeah. I think that is all the questions I have actually. Let us see anybody has raised the hands.
Bala, there is one question, I could say that in case of a wholly owned subsidiary company general meeting, what will constitute the quorum?
Yeah, it has come. Yes.
See, for all purposes, a wholly owned subsidiary company is a company. It has to have whatever the quorum requirements are there, it has to meet that.
Absolutely.
In a startups, when the CCPS are issued and their investment are reflected in the cap table, they have the clear voting rights in the general meeting.
What is the cap?
So what they are saying ki, as against the principles of section 47, where the preference shares are given a voting right only on the items which directly affects the right of a preference shareholder. Here the startup is intending to give a voting right to the CCPS holder also. Now, similar to what the equity holder is having. 47, I believe if it is a private limited company, when I am saying ki preference shares voting right can be taken away, can I interpret that preference shares can be given a voting right even? If it is a private limited company, I believe because 47 is one which is a charging provision, and if it is made not applicable and your articles are worded suitably, I don't think there should be any difficulty. It can be done. I have seen these kind of structures, especially in startups. Lot of Bangalore companies are having this kind of structures. Yeah, legally we need to examine, but prima facie on the premise that 47 is made inapplicable for private limited company, I think we can suitably word the article and perhaps achieve this objective.
So can I add here? So yes, you are right, Amitji. Very good afternoon to you. So yes, so in the articles, if it is worded that way, and in the articles from where the provision arises is from the terms of the shareholders agreements. So basically this happens in case of the foreign investors, because CCPS, we all understand generally in startups, this is how, but as far as the law is concerned, unless a provision is there in the articles, strictly as per Companies Act, until the conversion happens, they are in the nature of preference shares only, and they do not have voting rights. So that's the take over here.
See, basically, the private limited companies are nothing but glorified partnerships only. And a partnership form is always run by the partnership agreement. In case of a private limited company also, it's run by way of the articles unless until it is not going against the act. Whatever the provisions they want to have it in the articles, they can have it and then they can do it. So in this particular case, if they are giving a right to the CCPS, under the holders, which is there as per the articles, if it is permitted, and the equity shareholders have no objection, according to me, there should not be a problem. I agree with Amit for that.
Correct. Amit said very clearly in the beginning also.
Because it is not anything overriding the provisions of the act. Till that time it doesn't override the provisions of the Act, there should not be a problem.
So only thing is the condition, preconditions, it should be there in the articles. If the article is there, you can do so. Yeah. I think that is all the questions here. I think I can see somebody has raised a hand. Magesh
But
Mittal has
technically,
raised a hand.
1 minute, Bala, see, technically here also what happened is, though it is there in the articles, see, articles always is by a special resolution, you can bring the amendments, right? Say, for example, 76% people have agreed and the remaining 24% have not agreed. You are giving a right to the CCPS holders to vote. And with that, what is happening is the equity shareholders' votes are getting diluted. It may lead to a kind of an oppression, and at that point of time, the remaining minority shareholders may go to the tribunal. They can say, look, there is an oppression on us. So
Yeah,
it
that is
is, we
possible.
cannot say it is a blanket approval, we cannot say that. But one need to be careful about when you are giving a voting right to the CCPS shareholders, even in case of a private limited company also. So what I suggest is that in case that kind of a situation is arising, better to have, instead of articles, better to pass a resolution with the 100% consent of the equity holders, stating that they are giving that right to the CCPS holders to vote on that, so that tomorrow it won't be challenged. Otherwise, there is always a possibility to challenge that, what's called the kind of voting rights, in the tribunal. Okay.
I think we can allow the people to speak. There are two hands
Yeah,
have been
yes.
raised. One is the Asha Jain, one is the Magesh Mittal. You can unmute and speak. Any one of you. Magesh Mittal, you are there? Or Asha? Sorry, Asta Jain.
Yeah, can you hear me?
Yeah, we can hear. We can hear Magesh. Go ahead.
Yes, sir. Good afternoon. Actually, during the deliberations on the preference shares and the voting rights, it was mentioned that the if the preferences are issued on 31st March and it carries a coupon rate of 6%, then the dividend becomes due on 1st of April. But my point is the dividend does not become due until and unless the profits are available and the audited financial statements are ready. So the dividends, say the accounts are finalized and adopted in the AGM, say on 15th September. So the dividend should become due and payable only thereafter, not before that. So if there are no profits, no dividend can become due and payable. So that is the point which I want to make.
In
Bala
fact,
sir, I will
yeah,
address
yeah,
that.
please.
Mahesh ji, the point that we need to understand how the preference shares dividend is different from the dividend on equity shares. On equity, you have all the conditions of 123(1) to be met for the purpose of declaration of dividend, and that is a declaration on recommendation of the board of director if it is the final dividend. Whereas in the case of a preference shares, the contractual agreement is between the two parties, that is the company and the preference shareholder, that the preference shareholder will be getting a dividend at so and so coupon rate. Now, question only remains as far as the coupon rate is concerned, that is already pre-decided. There is no choice of a management that I have less profit whether I can declare or not. Only question that remains for understanding is as to when that dividend becomes payable, when that dividend is to be paid. Now, as far as due condition is concerned, it will become due on the first day of the start of your next period, that is on 1st of April 2024. Now, it will become payable. The payment can be deferred if you don't have a profit A. The payment can be deferred until you declare the dividend on equity, because you have only preferential right if you are talking about a right. So if my dividend is becoming due on 1st of April 2024, And on 30th of September 2024, when I am declaring a dividend on equity, then it becomes payable. You cannot pay equity dividend unless and until you pay preference dividend. So I'll put it this way. You are right on your part when you are saying ki, why you are saying it will become due, because due is because of the contractual obligation. The company and the shareholder have contracted that the dividend will be payable on so and so date, but payment because cannot be made if you don't have a profit, and payment will be done only and only when you are going for declaring a dividend on the equity share. That's what my point. Sir, please.
Mehta,
Sir,
Amit,
I have a point. I have a point.
One minute,
Allow me.
Mr. Jain. Mr. Jain,
Yeah.
1 minute. Amit, I differ with you and agree with Mr. Jain. Please refer to SS3. This issue has come up when we were formulating SS3, that whether preference dividend is to be declared by the shareholders or it is to be paid even without such declaration. We have brought this, if I am not wrong, very clearly in SS3 that it is to be declared by the shareholders only on such declaration, though it is a contract, there's no doubt about it, there is a coupon rate is there and everything is there. But declaration by the shareholders is very much required. Only after that, it becomes due and payable.
No,
So
sir,
I
it
think
is
if I am
other way.
not wrong, this particular issue has been elaborately discussed in SS3, okay, in the guidance note also. I think let us refer to that and we can discuss it maybe in the next
All
forum
right.
whenever we have something like this. I think if I am not wrong, Amit, we are going to have a webinar on accounts related issues that point of time, whether it is connected with that accounts and or not, but we will definitely bring this particular aspect there and we will discuss it. I'm sure Mr. Jain, you will agree with me on this. Okay.
Okay, now two more people are there.
Good afternoon, sir.
Yeah.
Ajay here. Sir,
Yeah.
I have a question. In an unlisted, public limited company, there are 50-50 JB. Now, there are, say, 12 shareholders because we have to adhere to that minimum 5 members. So, though it's a 50-50, there are other nominee shareholders. So, question is that during an AGM, suppose A Limited has all the 50% shareholders present along with nominees. In case of B Limited, only 20% shareholders are present along with nominees. So can special resolution be passed, assuming by vote of hand all the members have approved that resolution? Am I clear, sir?
See, in fact, it is not very clear. You say it is a 50-50% JV. Okay, the moment you say that, suppose there are two body corporates or they say A Limited and B Limited are two shareholders in that particular company. I presume, suppose if it is a public limited company, only that nominee shareholders you can have only in case of a subsidiary company. If it is not a subsidiary company, in case of 50-50% JV, there is no wholly owned. So I mean, the subsidiary company concept is not there. So you have to have minimum number of shareholders. If it is a private company, 2 shareholders are there, no problem. If it is a public company, you have to bring another 5 shareholders, not as nominee shareholders. They may be for all other purposes, they may be nominees, but on record, they're individual shareholders, number one. Number two, now the question comes, you are saying that one shareholder having 50%, he is attending the meeting. Another shareholder, he is having, you mean to say that the 50% shareholding of B Limited is held in the name of different shareholders, you mean to say? I couldn't understand what you said, that 50-50% joint venture means what? How can you have that a person is shareholder is attending but not having that 50% shareholding? I couldn't understand that. You have to have you have to say that how many shareholders, what is the shareholding pattern of the company. Then only we can answer that, otherwise not.
Okay, sir. We'll take it offline, sir. Thank you. Thank you.
Yes, okay.
Okay, Asta Jain?
Yes, am I audible?
Yeah, very much.
One of my doubts is, can a member appoint another member as a proxy? So in that way, a same member will also be a member in the same meeting and also a proxy for another member.
Sure, why not? You can.
Yeah, it can be done. There is no prohibition is there. It can be done.
And also, can a proxy be a part of the quorum for the computation of quorum?
No,
No,
proxy will not
quorum
be counted.
cannot be. As a member, if he is holding a share, yes, he can be, but as a proxy, he cannot be.
So
In
in
fact,
an adjourned meeting, consider there are only 2 members who are available for the meeting. So if they were in their own powers as members, they would form the quorum in the adjourned meeting. But what if both the members have appointed the other member as a proxy? So in that case, will they still form the quorum of the adjourned meeting, or will even the adjourned meeting stand cancelled?
can cancel.
Because with a proxy, you cannot count the quorum. That is very clear. Because members personally present, that is the wording which is used actually.
Exactly, sir. So
So when you say members personally present, when you are saying these 2 people are a proxy, that means members are not personally present, only proxy appointed by the members are present in the meeting.
yes,
That
sir. So
means
what I'm saying is the proxy which is appointed by a member is also a member.
No, if he is as a member attending on his member, yes, then it is okay. But if it is only a proxy, it cannot be.
Okay, so the proxy should be not on the behalf of a member, even though the person is still a member.
Yeah, member can attend on his behalf, but the proxy cannot be counted as a quorum. So in this
For
case,
example,
if you are saying
For
2
example,
members are,
Bala, 1 minute, Bala, 1 minute. If I am attending the meeting, I am a member of the company. I am a proxy for another shareholder. I will be counted as a member only. I will be counted as 1 for the purpose of quorum, not as 2. Let me put it in a different way. Suppose a body corporate is authorizing me. There are 4 body corporates who are authorizing me as their representative to attend the meeting and to cast vote thereat. In such case, what will happen is I will be counted as 4 members attending the meeting for the purpose of quorum. But if I am appointed as a proxy, even by the 4 companies also, but still I will not be counted for the purpose of quorum. At the same point of time, please ensure that, say for example, in case of a public company, 5 members are the quorum. So if 5 body corporates are authorizing 1 person, and if he is attending the meeting, he will be counted as 5. But for the purpose of quorum, 2 members' physical presence is required. 1 member cannot form a quorum. Physical presence. That's why minimum 2 members are required to attend physically. And that point of time, you can say 5 plus 1, 6 members have attended the meeting. That is how the quorum the quorum is to be counted upon.
It's a rather practical doubt. So there are 2 members. Can 1 member select the other person as a proxy and also be a proxy for other members? So what I'm saying is I'm present in the meeting as a proxy of another member, but I as a member have proxied someone else. So is that possible?
You will be counted as only 1 member, not the proxy will not be counted for the purpose of quorum. If it is a private company,
I'm a proxy of different member, and someone is proxy for me.
Whatever it is, proxy will not be counted for the purpose of quorum.
That's
as
it,
a
simple.
member, you will be counted. That's it.
Okay, thank you, sir, for the clarification.
I think that's all. I think so. Magesh with the hand is still risen, but I think he already spoke, I think. Yeah. So that's all I think. So there is nothing. Is one more
Thanks,
thing
Bala.
has come. One more thing has come. Sir, whether the section 55 allows infra company not having a sufficient profit to extend tenure of the preference share up to 30 years.
I think that is permitted, no?
It is already there. Infrastructure
there,
company, it is already permitted. Law itself is permitting it.
Correct.
Other companies is 20 years, infrastructure company 30 years is already there.
Yeah, it is permitted.
Yeah.
I have a small question, if you permit me.
Yeah.
It is different from the present topic. My question is, can a consultant become a MD of the company while simultaneously remaining the position of consultant also?
Well, I think this question is not connected to this webinar, and let us
Yeah.
not put it here. Let us defer it. When we discuss about the managerial persons, that point of time we will discuss it. Okay.
Thank you, sir. Thank you.
I think we can close the session. Thanks a
Yeah,
lot.
Bala, I say good night from my side because it is midnight, 12:30.
Thank you very much, Sudhakar, for your presence even at the late hours. I will be very much thankful to you.
Yeah.
Because you could share your valuable knowledge and experiences and your thoughts, etc. We have been missing for the last 4 weeks.
No, I told Atul Bhai and Deepthi also ki bhai, that once I settle down, I will be attending the webinars because once in a week I can be up to midnight, not an issue at all. Okay.
And it's so kind of you, sir. It's very nice of you. Very thankful to you.
Yeah,
Sir,
thank you.
Amit, you are excellent as usual because we have seen you in the past. Today also you have deliberated, you have explained, you have shared your thoughts. Very good, very knowledge addition to all of us. I think I personally learned a lot of things actually today with the deliberations, etc. Equally, that will be the case with the other people. And even at this time, we can see the people still are there, about 113. That shows what is the topic's importance, what is the significance of this particular topic. Thanks a lot for your valuable sharing of the information. Thanks a lot to Sudhakar as usual, because I don't have to specially thank you because you are part of it.
Yeah.
And Sachi has excellently presented. In fact, I must be separately recognize Sachi because today's presenter was somebody else. Due to some reason or something last minute, that was actually changed. And she has to do a lot of things. Yesterday, we had a mock session. After that, she has to modify a lot of things. And although she promised she'll send the thing, the reasonable hours, I told her it is not that easy job. She can take the time to send it, but with all the things, she had done a excellent preparation, excellent presentation, put it everything very nicely. Thanks a lot, Sakshi, for your good work, your homework. Very nicely you put it. Thanks a lot to everybody. Let us
Thank you, sir.
close the session with this, and we will meet at another session the next week. Thanks a
Thank
lot to
you.
everybody. Take a good weekend. Good night, Sudhakar.
Thank you. Good to see you, Amit, after a long time. And thanks, Sakshi. for
Same
coming
Thank
as
you,
a
sir.
casual. Thank you.
Good
Bye.
night.
Good night. Thank you.